Hey, y'all. Bear with me. Okay, here we go. Mm-hmm. Testing. Can y'all hear me? I'm trying out some new things today. I got a headphone set. Peace. True first of the North Star. Peace. I'm trying out some things today. How's my audio? Doug, how's my audio? How am I sound? Do I sound better than I usually sound? And that is the goal today, to see if I sound better than usual. Better than usual is the goal. All right. I'm not going to be on here too long, but I did want to jump up on here because I know y'all got questions. I know y'all got a lot of questions. And I want to make sure that we are clear. Sounds good? Good. What's up, Jermaine? Appreciate you joining me. All right, let's talk. And look, it looks like I don't have a delay. I might be cooking with gas today, y'all. All right, let me show y'all what I bought. I got a microphone. Look, I'm going the wrong way. I got a whole ass microphone, right? So my sound should be popping. And I got some headphones. All right. Near dare call it a conspiracy. Hey, none dare call it a conspiracy. Hey, how y'all doing? All right, so let's talk a little bit about the latest. If you haven't heard, there has been a fourth indictment. Unfortunately, I feel bad because I can't get my Instagram people on here. Let me see. I try to get some Facebook people. I try to cover all the bases, y'all, because if I don't do it that way, then on one platform or another, I'm going to get the same questions that I get. So I'm trying to. I have not been keeping up with. Hi, Miss Cagle. How are you? I have not been keeping up. Hi, Jai. Not keeping up with Brother Polite's case. Last I heard, it was adjourned. Again, I don't know when it's on again. Y'all probably know more. Last I heard on Polite was that there was plea negotiations on the case in Florida, and that there was a plea negotiation in place that involved jail, and that he was scheduled to take a plea. I don't know if that's still the case. Plea deals fall apart all the time. It's possible that it fell apart. I can't say, or that is still happening. When it comes on, sometimes prosecutors give people time to get their affairs in order, right? Because you're going to be up. So depending on what he claims he needs to do to tie up this, that, and a third thing, so he can take this plea and go off to jail, they may have given him time to do that. Polite's going to take a plea. Yeah, he very well may take. It looks like he is going to take a plea, but I don't know, because that brother tries to be very slippery. So we'll see. I know y'all will send me the video of it happening when it happens. Okay, let's talk about Donald Trump. But I'm going to talk about Donald Trump. I gotta get on Instagram. Hold on, so I could try to talk to all of the folks at once. Oh, Jesus. They never make this fucking easy. Are you guys on the Threads shit yet? That's like Instagram. It looks like Instagram's version of Twitter. People are gonna laugh at me because I still did not get a stand for the phone. So I'm gonna see if that'll work, and we'll see if the people on Instagram can hear or not. All right, so let's talk about the indictment. So there is a 41 count indictment. There are 19 defendants. Do you think Georgia is going to detain him pending trial? Rashida, no, I do not. I do not think any of those defendants will be detained pending trial. This is not the same type of case like the YSL case, right? So this case doesn't involve necessarily violence, right? While there are some accusations of threats and fraud and misrepresentation, it doesn't involve shooting and murder and conspiracy to harm folks. And so they're very likely won't be the same type of remand. Like a lot of the defendants in the YSL trial were remanded, right? I don't see them doing that. I don't say, should they remand their fucking asses? Hell yeah. But, that's not going to happen, right? And I'm all about managing expectation. Last thing I'm going to try to do is set y'all up to be disappointed, right? So I don't see that happening. I don't even see this fucking shit going to trial, but we ain't even going to get there, right? We're not getting there yet. Let's not get ahead of ourselves. So first things first is these people have to be arraigned on the indictment that's supposed to be scheduled. Fonnie Willis, who is the prosecutor in Georgia, has given them until the 25th to surrender themselves. When they surrender themselves, that is the time when it will be determined whether or not they will be required to post bail or anything of that nature. And they might. What I'm saying is that they won't be remanded, right? Will they make them post some sort of cash bail? Maybe. But it's more likely they will allow them to return on their own recognizance. I see you, Dennis. You want to join my live, Dennis? Not that I know how to let you join, but wait, no, I see a button here say invite. All right, text me and let me know if you want to join. All right, so here's what's happening. I want to show you something, and I'm gonna get jiggy with it. No. Listen, let me say this to these people. My people over on Instagram, jump either on, and I'm on both platforms because StreamYard would allow me to do this. So I'm on Instagram, I'm on YouTube, and I'm on Facebook. I'm on both. So if you follow me on those, go, because I got to get off of Instagram. Instagram is not gonna allow me to tell y'all anything right now. Come join me over here so that I can put my focuses here and focus on one platform. All right. So come over. All right. Love you. I really do. Peace. All right. I'm ending that. I have to fix my makeup first. Shut up. You know what? Shut up, Dennis. Oh shit. Hold on. Let me share. No, I don't even need to share that because I ain't say shit. Okay. All right. Hold on. I'm going to pull up this statute for you because, I think it's important for us to be informed. USC 1442. USC 1442. Let me pull that up. Fine Law Judiciary. I love Fine Law. Fine Law is a resource for those of you who like to do research on your own. FineLaw.com is one of the free legal research engines where you can go and get some information. Yes, I do watch a lot of King of Queens. And Doug, you didn't start that shit. We've been doing that shit forever. All right, hold on. I digress. No, I don't want to invite anybody yet. Hold on. Let me present. Hang on 1 second, guys. All right. So here's what I want to share you. So Mark Meadows filed a motion to remove, right? A motion to remove. And we're going to get a little into some constitutional law a little bit. Mark Meadows, who was the chief of staff for Donald Trump during his presidency, is also a co-defendant in this case. He has filed a motion with the federal court to remove this state action, this state prosecution from Fonnie to federal court. And he's done it under this section of the federal code. So this is 28 USC 1442. And it basically states that a civil action or criminal prosecution, which is what we have, that is commenced in a state court, which is what we have, and that is against or directed to any of the following. Any of the following, drop down to one. This is how we're going to read the statutory interpretation. You can read the whole thing, but I'm reading you the most important parts, right? We got a criminal prosecution that is commenced in a state court against or directed or directed to any of the following, right? The United States or any agency thereof, or any officer or any person acting under that officer or of the United States or of any agency thereof in any official or individual capacity for or relating to any act under color of such office or on account of any right, title, or authority claimed under any act of Congress for apprehension or punishment of criminals or the collection of revenue, blah, blah, blah. Mark Meadows is saying, oh, wait, let me finish this. Go back to the statute now. Any of these following people, right? These officers working for the government may be removed by them to the District Court of the United States for the district and division embracing the place wherein the case is pending. So that's Georgia. So that's what Mark Meadows did. Mark Meadows has motioned for the federal court to remove him, just him. Let me stop sharing because y'all can pull that up yourself. Did y'all see that? Was y'all able to see my screen? Because I thought I was sharing it, but you know I'm challenged, right? Somebody tell me in the comments if you was able to see that. Tell me. All right, while y'all tell me that. Anyway, so that basically, that statute, and it's not required, right? This is permissive language. It doesn't say must or shall. So we learned, thank you. Yay. Thank you, Kelly. Thank you, Nah. Thank you, Jermaine. Appreciate you guys. So just a little bit on statutory interpretation, permissive language, meaning that is not required. It doesn't have to happen, meaning that the judge could deny it, right? But this is the application that is going to be before the federal court, right? So we've got Mark Meadows who's made that because he's like, yo, I was fucking working. This is my job. I was acting under the color of authority, right? And so this should be in federal court. Now, this is a 10th Amendment issue, right? For my constitutional people who love the Constitution, the 10th Amendment, which is one that we don't talk about, the reservations clause, right? This is the reservations clause, which basically says that all of the rights that are not enumerated or that are enumerated to the federal government, those are the federal government. But if that shit is not spelled out that it belongs to the federal government, well, guess what? Then the states can do that shit, right? And so in order to make sure that the federal government runs well, the federal government wants to make sure that states can't come in and start charging federal agents, federal employees, federal agencies, right? Because that would inhibit the federal government from working. And the federal government is supreme over state governments, right? Supremacy clause. Let's throw that in there, right? And so this is the conflict. So basically, like you can't do that. You can't do that. So Mark Meadows is asking the federal court to take his case out of the state court of Georgia and have it in Florida. At which time, when they do that, he will make a motion to dismiss, right? What's up, Mikey? Mikey, look what I got, Mikey. So, Mikey, what we talked about is going to be at the house. I'm at the office, so I had to get a less sexy setup here, right? The office is going to be sexy, y'all. But this is, the office at home. My office at home, right? I have an office at home. I'm blessed to have an extra room in my house, and I have an office and I have an office at home. But Mikey, look what I did get. I showed them already, so I gotta show you. I got one for the office. Wait, let me not yell into it because I don't really know the sensitivities yet. I don't know none of what I'm doing. I'm just hoping I sound better. I know you're gonna get me right, Mikey, but I'm letting you know that I'm dialed in. I'm dialed in. You see it, right? So, okay, how it sound? They told me I sound okay. I don't know what's this little cord for. Sometimes I swear, I don't laugh at no. Oh, maybe this is clips on somewhere. I think I'm fancy right now. Okay, back to the indictment. I got the pink. The pink is gonna be at the house. But I had to do that through Amazon. And, that's taking a couple days. So I'm doing Karen Hunter tomorrow. I'm going to be on the radio tomorrow, Sirius Urban View 124. I'm going to be on at 4 p.m. And I wanted to make sure that I had this. The Amazon one is not coming until Saturday. The pink one, the pink microphone. So it's coming, and I'm excited about that. But this is pretty, too, because it's nice. It look like money. It look a little like money. Okay, now, so we don't know what's going to happen with that motion, right? It was a notice of motion, which has to be followed by an actual motion, which is the request of the court to take Mark Meadows out. Anyone who was working at the White House at that time that is charging this indictment is going to make the same motion, including Donald Trump, right? Donald Trump. And then this is where the politics comes, because we don't know who's going to be assigned from federal court to handle that case. And that judge very well may take this case from Georgia state court. They might take Trump out. They might take Meadows out. And I'm asking you, what kind of trial? What kind of trial? What have you done with the real Ike? Shut up, Mikey. I know this sound good, right? It sound good. What's it done, Mike? Wait, we gonna get on it. I'm gonna go to the questions in a second. How sexy is this trial in Georgia state court if Trump is not there? I'm just throwing that out there. Do you really think that Georgia wants to spend the resources that would be necessary to bring the other 17 defendants to trial? Do you really think they care that much about them? Maybe Giuliani, but I don't really think they care that much even about him. Right? They really don't. I just don't see it. I don't see it. Right? That's aside from the practical nature of this case. You've got 19 defendants. All of these defendants will have a defense team. They're not going to just have one lawyer. They'll all have multiple lawyers. Right? They will all be filing these motions. It will be paper terrorism. Do you hear me? Motion practice is going to be wild. And I'm not, and one of the things that really fucking annoys me is Fonnie Willis. I know that the prosecutors on this goddamn case, they're not getting paid extra. Are you paying them? They should get a fucking hazard pay for this bullshit you doing. They should get fucking hazard pay. Like can you imagine? When you are a prosecutor, you are required to have contact and communication with the defense. You have to make sure that you are disclosing everything that you have. You want to make sure that they have. You want to make sure if they have anything that you have, that back and forth with 19 teams of motherfucker. I'm gonna need double time pay. I'm gonna need holiday pay. I'm gonna need hazard pay. It's just crazy. It's not practicable. Right. So the other thing was, did you see that the grand jurors' names and addresses have been leaked? Baby, the grand jurors, this process is secret. This process is secret. So how? Please tell me how. When we know that Trump and his minions love to terrorize people, dox people, and all of that. You saw that there was a woman who was just arrested because she called the judge. First of all, you called this judge. She's Jamaican. She probably was like, what the blood clot? You called this judge and you threatened her. You threatened on voicemail. You don't even care. They don't even care. So you know that there's going to be jurors who are going to be afraid to even show up for the summons. Right. And if we look at YSL and how well that trial is going, they started jury selection in January. Jury selection in January. They're still in jury selection, by the way. You know, they're still, I said 8 months. 8 months of jury select. Get the fuck out of here. That's crazy. All right, hold on. Let me see what I can do here. Copy. Let me copy. Let me see how skilled I am here. Paste. Oh shit. Let me see. All right. The link is in there. Mikey, you coming in? Dennis, you coming in? Wahid. Assalamu alaikum. With Trump leading, it's not just political sour grapes. No, I think it could be a lot of that. I think it says more about our country that Trump is still leading. You know what I mean? It's a little scary that someone who has all of these allegations pending is still in the head. And I'm not saying that he shouldn't have any support, but to be leading, goddamn, that's. And so the whole thing about it being a conspiracy, I don't know. I think this is a problematic case because unfortunately, I think that these people, all of them, all 18, 19 of them, I think they conscientiously believed that Trump won or that the election had been stolen. They filed over 100 lawsuits. It's not like they didn't actually do shit, right, in support of their thoughts. So I don't know. I find this very problematic. Take your time. Okay, Dennis, I see you. Okay, look at me. Oh, shit. Dennis, you here?
Mic check, 1, 2.
Mic check 1 2. Now I hear you, but I don't know if anybody else can hear you. So talk, say something, and let me see if anybody else can hear you.
Mic check 1 2 1 2.
Oh, you did do that. That's what you did. All right, can y'all hear Dennis? Somebody put a 1 in the chat if y'all can hear Dennis.
Put a 1 in the chat, ladies and gentlemen.
Because I can hear you, but I don't know.
You sound like you're in stereo over there.
Yeah, I got a new microphone, Dennis. I am.
Oh my goodness.
Oh, they said we hear you. Yo, this is next level technology.
Okay, let me turn the camera on then.
Yeah, put your camera on. What you doing?
Hey,
There he is. There he is. Thank you. One's in the chat. I appreciate you. Look at this.
Bonnie Will's got the block hot right now.
Yeah, it's a problem. The leaking of the grand jurors' names and addresses is problematic. It's incredibly. First of all, the whole proceeding is secret. That had to come from her office. Where else is it going to come from?
So here's the deal. The lieutenant governor stated that the names of the grand jurors are public, but I pull grand jury documents all the time. I've never seen the names in the document, so this is really
what? That's some bullshit. In their address, their home addresses?
No, so that's where the doxing comes in. So they don't match the names with the and that's a problem. Who wants to sit on a jury trying to convict Trump?
No one.
No one wants to do that.
Who wants to sit on a jury where their lives might be threatened, where you giving them $25 a day? Kiss my ass.
Absolutely.
You only gonna get people who don't have jobs, don't have lives, don't have nowhere to be, don't have any of the responsibilities, because it's a sacrifice. Jury duty is a sacrifice. It's not just time. It's time and attention. You got to be dialed into that shit. You got to pay attention to witnesses and evidence. In this case, it's going to be complicated in that way. You've got 19 different defendants who are charged with 41 various counts. Not all of the defendants have the same count. So let me pull up the indictment.
Did you get a copy of the judge's order for Meadows? Did you see that?
I did not. They decided it?
Yeah, well, the judge, I got a copy of it. I should send it over to you.
Yeah, send it over.
So essentially, Fonnie Willis has up until the 23rd of this month to respond, and they have a hearing set for August 28th at 10 a.m., which I'll be covering inside the federal courthouse.
Yo, it's going down. Yeah, so, they might be successful on that shit. I told you that motion. We went over that. So what Dennis is talking about, guys, I don't know if I could go back and forth. If you can see my screen, this is that statute again, the removal statute, federal officers or agencies sued or prosecuted. That statute, that's what Dennis is talking about. So they're going to have a hearing on the removal proceedings, you're saying?
Yeah, on the 28th at 10 a.m. at the Northern District of Georgia Federal Courthouse.
Now, has Trump joined that yet?
No one else is filed.
So this is only they sent him out to test the waters. They sent Meadows out to
what I noticed in the order, the judge said, while you have a date for August 28th, the case in Georgia still moves forward until it's resolved. So that means those mugshots will be taken by the 25th.
Wow.
So it's not an automatic stay. This thing is moving. The judge said the train's still going, but he may pull the train to a halt, but we don't know.
Mikey,
yo,
what's going on?
Wagwan.
I was on with Mikey last night.
We're good, Mikey. We're good.
What's going on, brother? That's how homegirl answered the phone. Her Jamaican ass in the middle of the night. Wagwan.
Who on the phone threatening me?
All right, let's look at this indictment.
Let
me go back. This is new to me, so this all sharing screens and shit. I'm impressed with myself. Look at me.
Mikey, it feels good to be a passenger. It feels good to be a passenger.
Hey, yo, sometimes you just gotta let somebody else drive, and that's cool.
You see what I'm saying? If I crash, though, y'all better hold on. Y'all got your helmets? Because it's a bumpy ride.
I got my hand on the oh shit bar right now.
Right. It's a bumpy ass ride. All right, so this is the indictment, people. If you haven't seen it, So what I was saying before, we went over this last night. You see these numbers underneath the names? Those are the counts, the respective counts that particular defendant has been charged with, right? So you see that Donald Trump is not charged with all 41 counts. Mark Meadows is only charged with 2 counts, right? Everyone is charged with the first count, which is the RICO, right? That RICO, that Racketeer Influence and Corrupt Organizations Act, right? So basically, and I'll talk about RICO in a second because there's a lot of misunderstandings about RICO. But these are all the defendants, and this is all of the counts. Like every count, any forgery, conspiracy, fraud count that was in the Georgia Criminal Code, Bonnie said, let's charge that shit too, right? So these are all the counts. This is just stuff when they turn over indictments, table of contents.
Lord have mercy.
Uh-oh.
We're gonna die.
Oh God.
Is that me? Die? That's me.
That's not me, right?
Not me. I think it's
that's
Mikey.
That's my
Mikey.
That's my nap. That's my nap time, man. I gotta get up.
Nap time.
See, I forsook a nap.
Oh, that's not good.
Which is precious when you have a 5-month-old.
You need your naps. You gotta sleep when she nap, buddy.
That's right.
She don't sleep.
You gotta put some cereal in that milk there. I don't know what y'all doing. Stop playing.
She about to, yeah, we got we getting the spoons on Amazon. They coming right quickly.
Okay, good. Lady. That's all. She just need a little something on her stomach, let her sleep.
Can I
sounding like my grandmother right now.
I'm going to stick to your ribs.
Excuse me, Ike. I'm going to grab the order and send it to you right now. Just stand by.
All right, go ahead. Okay, so let me just break down.
Can I gloat real quick?
Absolutely.
I told you.
You told me what?
The new numbers are out. The polling numbers are out.
Okay, let's hear them.
Guess how? Okay, it's favorable or unfavorable is what they're voting on. This is a Fox News poll.
Okay.
For Trump.
Mm-hmm.
What do you think his numbers are?
I would say he's probably around 46.
46 favor.
% in favor. Yeah, favor. It could be higher, but I'm
61 unfavorable.
Oh, 60. So I'm about right then. 61. So that's like 39 unfavorable, right?
Yeah, he's stinking up the joint. They don't like this. Told you they don't like this. Even if you're saying, oh, there's nothing to it. Yeah, they'll. You're a lawyer. You're used to court
right, because here's the thing,
this
Mikey.
Is scary for normal people, you know.
Right, because normal people haven't sat down and listened to the lawyers analyze this when it first comes out, right?
Yeah. Everyone's
like, oh my God, indictment. And most people think that indictment has some evidentiary weight. It does not. It doesn't. And lay people think that, and that is what a lot of people are gambling on, that people will just have an emotional reaction to this instead of an intellectual one, right? And so the same is true for Donald Trump. He knows that people don't know the ins and outs, so he's going to make this into, this is a witch hunt, and these people are out to get me, and this is why I need you to send me $5.
Did Jack Smith jump the shark by making it so long?
I don't think so. I think,
did he approach this the wrong way? If he was trying to get what he was after, is this, because from what it sounds like is like, if all of that is what he wanted, going about it at the same time wasn't the way to do it.
No, I think Jack Smith handled it better than any other prosecutor, honestly, because in his indictment, he specifically lays out why the acts and the comments and the things that Trump did are not protected by the First Amendment, right? Because that was their go-to defense.
He said, I got freedom of speech.
He's like, well, let me address that shit here in the indictment.
Yo, I can't lie no more.
Right. Well, you can lie. You can lie.
Y'all saying I can't even.
You can lie. You can lie. You can absolutely lie. You can lie. You just cannot threaten people. You cannot incite violence.
But I was lying.
Well, that's protected if you could. If he believed that, that's my issue with the false statements. If he believed it to be true, how is it a false statement?
If it's internally, if it has internal logic,
Even though we think that he's crazy, but if he believes
to him,
and he's got advisors, he's got lawyers filing lawsuits on his behalf. You know, I'm thinking that there's support for that. All right, hang on. I got to check something from Dennis. Dennis, you sent it? Oh, he's let me see. Let me check.
Are you eating that bottle? Yes, she is.
Okay.
She holding her own bottle. I'm so grateful. I
Okay.
can't stand holding that bottle. It's like a fucking Brazilian jiu-jitsu match. She just kicked it and scratched. I'm like, girl, if you don't stop fighting me. Ripping the bottle out of her mouth.
5 months. Oh, what thought?
I'm
Okay.
finna roll in the mat with you. You finna hold your own bottle.
Okay. So let's talk a little bit about RICO. RICO used to be used for organized crime, the mafia. It was working so well. And it's not for you, Mikey. It was working so well. Prosecutors expanded its use and started using it in other areas, in labor, in union, in fraud, in all other manner of cases. And we saw Fani Willis use it in Georgia when she prosecuted the teachers who were convicted for rigging the test scores and things of that nature, right? So we've seen RICO be used in a number of ways. We also saw RICO be used civilly, and I don't know if a lot of people have made this distinction. That Sheen company, the clothing company, Shine, SH, is it EIN? I know that there's a lot of back and forth about how that's pronounced. I really don't give a fuck.
I thought they was talking about the rapper. I'm like, damn, he did something else.
God, no, not that guy. Bro. No,
you stay in trouble.
I think it's Sheen. It's SHEIN. Anyway, they have been sued by other clothing makers saying that they are stealing their designs. Oh, look at me tap. I hear my microphone, doesn't it? Stealing their designs, copyright infringement, all of that shit. And so they brought a civil RICO suit against them, right? So RICO can be state, can be federal, can be civil, can be criminal. Not every state has a RICO statute, but many of them do. All right.
I sent it to you. Check your message. It's there.
All right. Let me check.
To your phone.
You send it to my phone? Why would you send it to my phone? What I'm supposed to do with that? I can't show nobody that on my phone. I'm on.
Hey, you did it to me yesterday. I ain't trying to.
I did it. I sure did.
12 hours ago, you did it to me. So.
Just drop it to your computer. You got a Mac, right?
I sure did it. Ew, no, you did not say Mac. Why would I have a Mac? We've been over this, Mikey. Would you tell me? Why would I have
making sure now?
A Mac. Yeah.
Not a
Mac.
They make phones only and tablets.
Meadows. This is so much better. Oh my goodness, I can actually hear. All right, hang on. Let me go get that. I'm starving.com. I need to order some lunch.
.org,
right? Notice of removal, Fulton County. Okay, let's go. We're going to read this in real time. Let's read this in real time together. Let's do it in real time together.
Read it together.
All right. Notice of removal, Fulton County Superior Court, State of Georgia versus Mark Meadows. Just a matter. Appeared before the court following defendant Randall's notice of removal under that statute we talked about. The court enters the following order in satisfaction statutory requirements for the state criminal prosecution removed for the following reasons. The court concludes that summary remand under is not required based on the face of Meadows. Right. Remember I said it's not per se. It's not it's permissive language as opposed to mandatory. That difference between may be removed and shall, because shall is must. Shall is if we make out these statutory requirements, you must move our shit. Right, but he's saying on his face, you got it, but I'm gonna need a little more. The court concludes that summary remand, meaning that without a hearing, without us having to have a conversation about it, is not required. That's what summary remand on Meadows' notice to remove. Background, grand jury, returning indictment. Procedure 2020 presidential election violated a number of Georgia criminal statutes. Meadows served as the White House chief of staff under President Donald Trump from March 31st, 2020 to January 20th, 2021. The indictment first charged Meadows with violating Georgia's RICO statute, specifically alleges the following as a predicate act. So RICO and many of the state actions require what's called overt acts. Overt acts means that you are doing something in furtherance of whatever the goal is, whatever the goal of the enterprise, right? The goal of the enterprise here, as alleged, was to overturn Georgia's like certification of the, their certification, because Georgia was given their state to Biden, right? So the enterprise was to have Georgia go to Trump, right? And all of those electoral college votes would have gone to Trump, right? So in furtherance of this, these predicate acts means these are the acts they did to support that. He met, this is Meadows met with President Trump, with Michigan officials about election fraud in Michigan. He messaged a United States representative from Pennsylvania and then met with Pennsylvania legislators about holding a special session. He met with John McAtee to request a memo about a strategy for disrupting and delaying the joint session of Congress on January 6th, relating to counting electors. That act has nothing to do with necessarily Georgia. Like, some of this is overlapping from Jack Smith shit too, right? He attempted to and was prohibited from physically observing a non-public Georgia election audit. My issue with these as we read them is that none of this stuff is criminal, right? If your boss says, yo, go watch them count those fucking votes, and you go down there and they say you can't come in and you leave, how the fuck is that a predicate act? Like, come on. I mean, reaching is a thing, and I think they reaching the fuck. I mean, some of this shit is really reaching. And when you have shit like that, it undermines the credibility of some of the shit that actually might be legitimate.
Is there such a thing as like employment immunity? Like they have qualified immunity for all these cops. Do you have something that protects you as a worker?
Not that I'm aware of.
Well, then I don't know if you got something to be protected from.
Well,
he's doing his job. Where's the criminality here? If you have a conscientiously held belief that there has been fraud in this election, isn't it your job to go ask questions?
Well, he's working under the color of his authority.
Of course. So that's what he's doing, right? Okay, so let's just keep going through. Let's finish the order. So these are the things that they're recognizing, that these are the acts that they're saying are predicate acts. Message to Chief Investigator Watson about potential for a quicker signature verification process of Fulton County election results if the Trump campaign assisted financially. Solicited, along with President Trump, Georgia Secretary of State Brad Raffensperger to violate his oath of office by altering the certified returns for presidential electors. Now, remember, the way that this is written by the prosecutors. If I was the defense attorney and I was writing this, I could write this same sentence and these same acts and make it sound like nothing happened, right? So this is also a form of art in how you draft shit. Okay. August 15, Meadows filed a notice of removal, criminal indictment. Meadows asserted federal jurisdiction exists under 28 U.S.C. 1442 as he was a federal officer acting under the color of his office at the time of the acts alleged. Look at that. Didn't we just talk about that? I'm fucking psychic. The events giving rise to the indictment occurred during Meadows' tenure as White House Chief of Staff and are directly related to that role. He specifies that his official duties as Chief of Staff included arranging meetings for the President of the White House, communicating, making phone calls and shit. I'm sorry, it didn't say that. It doesn't say that, but that's basically what they're saying. Furthermore, he states he attempted to go to the location of Georgia election audit in his role as White House Chief of Staff so he could report to the president about the ongoing audit, as I said. All right, with the following background amount, the court now determines whether it clearly lacks subject matter jurisdiction over this case and thus requiring summary remand. I'm assuming they say they have jurisdiction. Legal standard: federal courts are courts of limited jurisdiction. They possess only that power authorized by the Constitution and statute. One such jurisdiction statute provides federal jurisdiction over any officer. That's the statute we read earlier, right? And the statute is cited in an incident of federal supremacy designated by federal form in which to raise defenses arising from their official duties. Section 1442A1 removal requires first the case must be against any officer, agent, or agent of the United States, blah, 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 regardless of whether the federal court would have had jurisdiction over the matter had it originated federal court. Once statutory prerequisites provided independent jurisdictional basis. 20 allows specifically for the removal of the state criminal prosecution under certain conditions. Procedurally, the notice of removal must be filed not later than 30 days after the arraignment in state court. Remember, they haven't been arraigned in state court yet.
So he prematurely filed.
No, or at a time before trial, whichever is earlier. So it can't be later. It doesn't say it can't be earlier. Right? Remember, statutes are very particular. If they wanted to say you can't file it earlier, it would have said that.
Right.
It can't be filed no later than. So he's on notice that he is going to be arraigned. He's been indicted. There is a charging instrument in Georgia State Court. So I don't think it's too premature.
Bonnie Willis filed a motion the other day asking the judge to set arraignment for September 10th.
Okay. Okay. All right. Removal must, so those are it must contain all grounds for such removal. Upon receiving a notice of removal, the federal district court must examine the notice properly and promptly determine if the summary remand ought to be granted based on a clear lack of jurisdiction from the face of the notice. And if summary remand is not ordered, then the district court must promptly hold the evidentiary hearing to determine disposition, blah, blah, blah. There we go. Moreover, the filing of a notice of removal of criminal prosecution in section 1455 shall not prevent the state court. So they can still go forward, obviously, even though the judgment of conviction cannot be entered until the prosecution is remanded, right? So they could have the trial and all of that, but the judgment of conviction can't be entered until the case is back in state court, but that's not an issue. According to the foregoing standard, court first determined Meadows' removal action meets the procedural prerequisites of 28 U.S.C. 1455. Yes, right? And Meadows removed this action one day after the indictment was filed and thus satisfied the timing requirements. So we said that, right? Because statutes are very specific, right? And the language, how we think about statutes is that the people who are writing them are really smart. Even this is not true. This is how we think about them. You can argue with your mother. We think that about them, right? Because we voted their legislators, we voted them, we put them in place. So we think that they're smart. And so we think that if they have an intention about a particular thing, they would include it in the statute. So we don't include things in the statute that's not already there. We don't read into a statute. We accept a statute on its plain face. We go with the plain language. And so the judge then is just supporting what I'm saying and saying that, look, there's a charging instrument. The indictment has been filed. And so this action is timely. All right. Moreover, his filing of removal contains the grounds for removal, including a basis for federal jurisdiction and satisfaction of 1445B2. The court now must look at the notice of removal filed and exhibits attached to determine if it clearly appears that removal should not be permitted. Put differently, the court must determine if it clearly lacks subject matter jurisdiction over the removal action. The court has not found any test to govern whether the removal documents clearly appeared to preclude removal, to be sure.
Please explain subject matter.
Let me finish. Subject matter jurisdiction is the court's authority to hear a type of case, a particular type of case. Let me give you an example. For instance, let's say you wanted to get a divorce, right? There are only certain courts that are authorized to grant you a divorce, right? So
criminal court.
No. Here in New York, you could only get a divorce in Supreme Court. You could not go to family court, although it sounds like you should be able to, right? Because it's a family issue.
Sounds family adjacent, yeah.
It does, right? So, but you can't, because the family court does not have subject matter jurisdiction over divorce actions, right? So family court cannot hear that type of case. And so what the court is looking to see is you've satisfied the statutory requirements for us to remove, but we now have to look at the substantive claim to see if we have the subject matter jurisdiction over this type of case, right?
That's key.
Right. So they're saying we don't have any guidance, it sounds like. The court has not found any tests to govern whether the removal documents clearly appear to preclude removal. To be sure, 28 U.S.C. 1455 merely provides procedures that must be followed in order to remove a criminal case from state court when a defendant has the right to do so under another provision. Thus, when a removing party fails to meet a requirement of the underlying basis for federal jurisdiction, then removal of the state criminal prosecution is not permitted. So the court has to have subject matter jurisdiction. So that's probably what the hearing is going to be on. Rejecting removals based on federal office jurisdiction because the removing party failed to allege that he was a federal officer. So we don't have that issue here. Here, the court determines that the notice of removal and attached indictments are sufficient to show that summary remand is not clearly required. In other words, it is not immediately apparent from the face of the document that the court lacks subject matter jurisdiction under section 1442A1 over this removal action. That means that the court believes they can hear this case, that they can preside over this type of case. Meadows asserts federal officer jurisdiction under 2814-42, which requires showing that the case is against any officer, agent, or agency or agent of the United States for any act under color of such office, and that the federal act or agency being challenged raises a colorable defense arising out of its duty to enforce law. I didn't hear that. I didn't hear him levy a defense. So if we look at that again, right, which requires showing that the case is against an officer, we got that one. And you see this and right here? You see this and? This is what we call conjunctive, meaning we have to read them together, right? So you have to have both of these things. If it said or, it'd be okay for you to have one or the other. But this means that he has to establish both of these elements. One, that the case is against an officer, agent, agency, or agent, which he did, and that the federal act or agency being challenged raises the colorable defense arising out of its duty to enforce federal law. The notice of removal indicates that I think that's the deficiency. The notice of removal indicates that Meadows held the federal role of White House Chief of Staff, right? Meadows also submits that he was acting in his capacity when all the criminal acts allegedly occurred. Meadows finally asserts he has a defense to these criminal charges that arise under federal law, including federal immunity defense under the Supremacy Clause of the federal Constitution, specifying the federal immunity defense and arguing its application to Meadows.
See, I'm smart.
Accordingly, the court determines that Meadows' notice of removal is sufficient to withstand summary remand under 1455. The court emphasizes that this order offers no opinion on the court's ultimate determination of its subject matter jurisdiction over this case or Meadows' federal immunity defense. Pursuant to 20 and under, the court will take its final determination on these matters once they have been completely argued and briefed and are ripe for the court's review. To reiterate, this court's limited conclusion is that the court, based solely on the face of the notice of removal in the indictment, does not clearly lack subject. I hate when courts speak in the negative.
The triple, quadruple negative shit.
Why would you do that?
Lazy.
Like, what? Oh,
they don't know how to backspace.
Like it's pins and needles now. Like
you say you do not lack something, that means you have it. Just say that. Speak in the affirmative.
Say have.
Right. You have. Oh my God.
You exited the vehicle. You got out of the car.
Right.
I'm wasting all my fucking characters.
Okay. Thus, the court will proceed with an evidentiary hearing pursuant to 28 U.S.C. 1455 B5. What the foregoing, the court concludes the face of the notice doesn't an attached indictment do not clearly indicate that summary remand of this matter is required. No opinion whether removal will be permitted or on the federal immunity defense is being made at this time. Court orders that the parties participate in evidentiary hearing concerning the notice of removal of the indictment. They're not clear on saying what the issue is at the hearing. The defendant immediately serve the Fulton County District Attorney Fonnie Williams with a copy of the notice of removal and copy of this order once the Fulton County has been served. Okay, so I think I understand only because of this last part. It looks like this was filed, and I don't know if Fonnie has responded.
No, she didn't.
So I think that's why the court is not going to make a final ruling, because one of the things they said was that it wasn't ripe, meaning that they probably don't have opposing papers, right? So they don't want to make a decision until they have heard from the opposition. So that's probably what's going to happen at the hearing. We'll give time for that.
It appears that Meadows may prevail in this.
Yeah, it looks good.
Yeah,
it looks good. It looks like it does. But I said that, right? Did I not say this looks like? Yeah. And how is this indictment going to look? Because if Meadows prevails, Trump is going to prevail, right? And so they take those two dogs out the race, and this race becomes a lot less interesting.
Right. So now are you going to go for the powers and the publicists and the black
publicists? Yeah. That's what you get. You on the hook. Is his belief alone enough to excuse his actions? I believe all the money in Chase Bank is mine. Should it be okay for me to come and take it? Hey, Karen, that's a great question. But it's not his belief alone, right? It's not his belief alone. He has advisors
Right.
He has attorneys. He had Rudy Giuliani, who was a federal prosecutor. He had Sidney Powell. He's got the White House counsel. He's got those lawyers who are saying things that might, even if those lawyers were saying things that were somewhat different, right? He had some advice.
He had a lot of advice.
He had lawyers filing lawsuits all over creation. So it's not just that it was a belief. They believed they had evidence. They believed they had, the smoking gun here, there, and everywhere.
So it comes down to like the chutes and ladder game of somebody knows one thing. Does that trickle the dominoes? Is that what kicks it off? That proves that so and so like that they can prove
I
that.
think this is hard
if
to
they
prove.
have if they have some of those tapes of people saying, "Well, yeah, I know it's a scam," but we got to get people to say, like, if he says that on a tape,
if we find that, if you could find him saying, "Listen, I know I lost, but we've got to."
That's what he said on the Georgia tape, though.
No,
I
look,
don't think I heard that.
You didn't say it.
I heard that.
He's like, but I can't do that, sir. That's something. I was like, look, man, I think you like your job. You sound smart. You sound intelligent. You sound like your hands are bigger than mine. You could probably hold a water bottle with one hand. You sound like a more alpha male than me. You just and then he butted the guy up, and then he said, "But I just need that 11,732 votes. I just need you to find that.
I need you to go find that. Go recount."
That's not a confession.
That's it right there. Go recount.
That's not a confession, Mikey. I'm frustrated with this process. Look, I'm playing devil's advocate. Obviously, I don't want Trump to be president again. I don't want y'all to think that I'm over here trying to defend this man. That's not. But I'm not going to respond emotionally about this shit. I told y'all I don't do that. I'm going to look at this as an attorney. I'm going to look at it critically, and I'm going to look at what based on my training and experience. Right? I mean, he's going to be. I really think he's going to be president. I think he's going to win again. Unfortunately, this is sad, but I think that's what's coming.
And I think it's going to be hard for that prosecutor with all those lawyers to convince the jury that she's going to have to get half of those defendants out of this case before they go to trial. Yeah, he may be the first one.
Yeah, the first two. And I'm telling you, once they go, this case is going to fall apart. Do you really think Georgia's going to spend the resources and money?
They don't have it. They can't pay their lawyers.
How are they gonna pay the prosecutors? They're gonna be running.
They can't pay.
They're gonna be burning it at both ends. These prosecutors.
And he's gonna drain the resources of the prosecutor's office.
Yeah.
I just got a text from one of my sources. Tyler Perry is covering the whole tab. Don't even worry about it.
Get out of here, right?
He's gonna foot
right
the
after
bill.
because he don't have to buy. He's not buying BET anymore, so he got a little extra.
Right, he got some extra. He liquidated some assets.
Paramount's not selling it. He's not
right. That's true. All right, they not selling it anymore. They took it off the line.
All right, got some money suddenly available.
All right,
him and Byron Allen.
Any more questions? Those ballots being mishandled in Georgia with this. All about they go footage of funny business in Georgia. Gangsta Slim, I'm trying, bro. I don't know what you're trying to say here. What you trying to say?
I got to
run. Those ballots being all right. Go ahead, Mikey. We leave. I'm out of here in about 3 minutes. We'll take this last question and I'll scroll up and make sure I didn't miss none. Gangsta Slim, ballots being mishandled in Georgia. There was some allegations that there was ballots mishandled in Georgia, and that's what I'm saying. There is some basis for the beliefs that some of these people hold. Now, a lot of those things have been debunked, right? But when you hold a belief, you might not accept the debunking of that belief. I mean, a lot of y'all still holding on to Jesus. So, oh shit, I said it out loud. That's right.
so let me ask you a question, Ike.
Okay.
We seen the video. I don't know if you've seen a video of Cuddy, the publicist, and her talking to the young lady at the.
I did see that video. Hold on, I'm trying to get my camera life together. Right. I probably need to
cut in half your head off. So you got to bring.
I'm cutting my head off. I know. I think I need to
bring it up just a little bit. Yep, that's perfect. Yep.
And I had too much headspace there. All right, cool. Go ahead.
So you saw the video? What did you
see the video?
You didn't see the video?
I did.
What did you make of that and what she was saying?
I thought it was horrendous. I thought she was a pawn, right? Because these poll workers were Black women, right? The mother and daughter, the Freemans, if I'm not mistaken.
Yeah.
Right. And so they found this Black publicist, this Black woman, right? She's a woman, Black woman.
Yeah.
Sent her over to this other, just, because she's Black. They used her. They were like, you go because she'll trust you. And you go over there and you basically tell her fuck shit. Like, listen, you're not safe here.
It was pretty intimidating.
You're not safe here. You saying something like that to somebody. In 2 days, people are gonna swarm your house, and it was bad. Did you guys see it?
And did you see the Roger Stone video where he's talking to one of his aides about how the electors, getting to the electors is important?
Is Roger Stone like an unindicted co-conspirator?
He might be. After that video, he might just be. The fact that if she knows that video existed and she didn't name him in the indictment, he might be probably one of the unindicted. He
might be unindicted. He because he went to jail already, right?
Yeah.
He like, I'm not going back. And Trump, you ain't give me no damn pardon.
Right.
You ain't give me no pardon. So he might be a little salty. He might have a little sour grapes. Man,
30 some unindicted people. Those are probably the people who are going to turn on these people.
Oh my God! All right, Dennis. Well, I'm gonna jump up off here because I actually got some work to do and whatnot. Y'all catch me tomorrow on Karen Hunter Show on Sirius XM Urban View Radio, and channel 126 at 4 p.m. Go ahead, Dennis. Where can the people find you, Dennis?
Just follow me on Twitter at Mr. Dennis Byron on Twitter, and also on Hip Hop Inquirer on the YouTube. Or you can follow me at Mr. Dennis Byron on Twitter, Instagram, all socials. But on YouTube, it's Hip Hop Inquirer. And that's at HIPHOPENQUIER.
All right. Yeah. All right, family. Thank y'all for joining us today. See y'all around, getting it together. Y'all gonna see me more often. Y'all gonna be tired of me. Y'all gonna be tired of me.
Sound. You have that sound now.
That sound. What? All right, family. It's your girl, Ike. I love you. I really do.
Yes.
Y'all have a blessed day. Peace.